Section 14.4. Mediation. Like negotiation, mediation provides that if no settlement is reached, all information provided by all of the parties and by the mediator during the proceeding becomes privileged. Like negotiation, just like in negotiation, where parties discuss possible settlements in confidence, mediation also ensures that discussions remain protected. If no settlement is reached, if the mediation fails and the parties do not agree on a resolution, they can proceed with litigation or arbitration. All information provided by all of the parties and by the mediator. This includes statements, admissions, settlement offers, and discussions made during mediation. Becomes privileged. Privileged information means it cannot be used as evidence in court or in future disputes. Even if a party participates in mediation, they are not obligated to settle the dispute. Here's why. 1. Voluntary nature of mediation. Mediation is a voluntary process in most jurisdictions, which means that while the parties may agree to try to resolve their dispute through mediation, they are not required to settle. The mediator's role is to help facilitate communication, clarify issues, and encourage settlement, but they do not have the power to impose a decision or force an agreement. 2. Mediation as a non-binding process. Unless the parties reach a settlement agreement and choose to formalize it, such as by signing a binding settlement agreement, the mediation itself is typically non-binding. This means that a party can leave the mediation without agreeing to anything, even if they have participated in the discussions. 3. Freedom to refuse settlement. At any point during mediation, a party has the right to reject any proposed settlement or offers from the other party. This is because the final decision to settle is always in the hands of the parties involved. They are free to walk away from the mediation process without agreeing to a resolution if they believe the proposed terms are not in their best interest. 4. Outcome of refusing to settle. If a party refuses to settle during mediation, the dispute may remain unresolved, and the parties could proceed to litigation or another form of dispute resolution, e.g., arbitration. However, participating in mediation does not force a party into a settlement they are not comfortable with. 5. Why mediation? While a party can refuse to settle, the goal of mediation is to create a space for collaboration and negotiation where both parties can come to a mutually acceptable agreement. However, it is understood that not all disputes are resolvable through mediation, and a party is free to decline settlement offers if they feel that the resolution isn't right for them. Conclusion. Even if a party participates in mediation, they have the right to refuse to settle and choose not to reach an agreement. Mediation is a process designed to help resolve disputes, but participation does not force a party to agree to any terms they don't find acceptable. Multiple choice questions. 1. What is the role of a mediator in the mediation process? A. To make a binding decision for the parties. B. To facilitate settlement discussions between the parties. C. To act as a legal representative for one of the parties. D. To enforce a settlement agreement. Answer. B. To facilitate settlement discussions between the parties. 2. Mediation is effective in resolving which types of disputes? A. Only complex multi-party disputes. B. Only small, straightforward disputes. C. Both complex multi-party disputes and small, straightforward ones. D. Only disputes that involve financial matters. Answer. C. both complex multi-party disputes and small, straightforward ones. 3. Which of the following is not required for mediation to be successful? A. The parties must have a genuine desire to reach a settlement. B. A judge must be present to approve the settlement. C. Each party must be represented by someone with settlement authority. D. The mediator must have the trust of all parties. Answer: B. A judge must be present to approve the settlement. 4. What happens if no settlement is reached in mediation? A. The mediator makes a final ruling. B. The case automatically goes to court. C. All information shared during mediation remains privileged. D. The parties must start the mediation process over again. Answer: C. All information shared during mediation remains privileged. 5. Why must the mediator have the trust of all parties? A. To ensure fair and effective facilitation of settlement discussions. B. To make legal decisions on behalf of the parties. C. To enforce a legally binding settlement. D. To provide legal representation for one of the parties. Answer: A. To ensure fair and effective facilitation of settlement discussions. 6. What is usually the first phase of mediation? A. The mediator makes a ruling on the case. B. The parties exchange opening statements. C. The mediator meets privately with each party. D. The mediator presents a final settlement proposal. Answer: B. The parties exchange opening statements. 7. How does a mediator differ from a judge or arbitrator? A. A mediator can impose a legally binding decision. B. A mediator is allowed to meet privately with each party. C. A mediator represents one of the parties in the dispute. D. A mediator cannot communicate with both parties separately. Answer: B. A mediator is allowed to meet privately with each party. 8. What is one of the key functions of a mediator? A. To make a final decision in the case. B. To act as a legal representative for the weaker party. C. To provide a reality check and help parties regain objectivity. D. To disclose confidential information to the opposing party. Answer: C. To provide a reality check and help parties regain objectivity. 9. When a mediator meets privately with a party, what can they do? A. Disclose all confidential information to the other party. B. Help the party understand the strengths and weaknesses of their position. C. Take sides and argue on behalf of one party. D. Change the legal terms of the case. Answer: B. Help the party understand the strengths and weaknesses of their position. 10. Under what condition can a mediator share confidential information provided by one party? A. If they believe it will help the case move forward. B. Only with the consent of the party that provided the information. C. If the other party requests it in writing. D. At the end of the mediation process. Answer: B. Only with the consent of the party that provided the information. 11. Why might a party lose objectivity in mediation? A. Because they do not have a lawyer. B. Due to being involved in the case for a long time. C. Because the mediator has already made a decision. D. Because mediation does not allow private discussions. Answer: B. Due to being involved in the case for a long time. 12. How can a mediator help parties move past roadblocks? A. By making a final ruling on the dispute. B. By revealing confidential information to both parties. C. By sharing non-confidential facts that one party may not know. D. By forcing the parties to accept a settlement. Answer: C. By sharing non-confidential facts that one party may not know. These MCQs test knowledge of mediation phases, confidentiality, the role of the